Hillchos Shluchim Eshuttin, Chapter 2:1. A non-Jew may never be appointed as an agent for any mission whatsoever. Similarly, a Jew may never be appointed as an agent for a non-Jew for any mission whatsoever. This concept derived from numbers, and so shall you offer also yourselves. This is interpreted to mean just as you are members of the covenant, so to your agents must be members of the covenant. The principles apply to the entire covenant. Moreover, the converse is also true. Just as your principles are members of the covenant, so too in every aspect of her law, the principal must be a member of the covenant too. A man may appoint either a man or a woman as an agent. He may even appoint a married woman, a servant, or a maidservant since they possess the developed intellectual capacity and are obligated to perform some of the mitzvah statement of service. Agents with regard to financial matters, a person who does not have developed the intellectual capacity, i.e., a deaf, mute, mentally or emotionally unsound individual or a minor, may not be appointed as an agent. Normally, they appoint agents. This applies both to male or minor and female minors. Accordingly, a person who sends a son who is below the age of majority to a storekeeper for oil, the storekeeper measures out its worth of oil and gives the child an isser as change, but the child loses the oil, and the isser he gave him, the storekeeper was not able to pay for. The father sent the child only to inform the shopkeeper that he needed the oil. The storekeeper should have sent it with him. So a person simply lost plan on analogous situations. If whoever the recipient explicitly told the storekeeper to send it to me with the child, the storekeeper is not able to, and a person tells a colleague, Yomi Amana, send it to me with so-and-so. If there desires to send it with the creditor, send to the creditor with that person, he discharges his obligation, is no longer responsible for the money, even the person named was a minor. This applies regardless of whether the money was given as a loan or as an interested object. Similarly, when two people agree on a stipulation between themselves, and whoever desires to send an object to his colleague will send it with whomever he send or desires to send it, may send it with whomever he sees fit, provided he is appropriate to transfer such an article. If the article is stolen or lost on the way, or the agent denies receiving it, the sender is not liable to rationales that every stipulation regarding financial matters that is accepted by the principles is binding. For when an agent buys or sells an article and notifies the other party that he is acting as an agent on behalf of another person, he's acting as an agent for another person in this transaction. It is discovered that he violated the instructions given to him by the principal. The sale is nullified, and the article must be returned even if the shicha was performed. If the agent did not notify the other party there was an agent, the transaction is binding. The agent must then satisfy the principle. 5. The following was applied. Reuben purchased a field from Shimon and told him, I purchased it on behalf of Levi, and drew up a deed of sale for Levi. And afterwards Reuben told Shimon, I purchased the field for myself, draw up a deed of sale for me. The seller was not compelled to draw up another deed of sale for Reuben. However, Reuben, the stipulation of the outset telling the seller, I am purchasing it for myself, I am having the deed of sale drawn up on behalf of Levi, also only so that people will not know that I am the buyer. Reuben make a compel Shimon to compose another deed of sale in his own name. 6. A broker is an agent except that he receives a fee for his services. Therefore, if he deviates from the instructions of the owners, he must take responsibility for the loss he caused. What is implied? Reuben gave an article to Shimon, a broker, and told him, sell this article for me, but do not sell for less than 100 zuz. Shimon sold it for 50. He must repay Reuben 50 from his own resources. If he sold it for 200, Reuben receives everything. Similar principles apply in analogous situations. If Reuben claims, I told you to sell for 100, and the broker says, you told me 50 and I sold it for 50, the broker must take an oath mandated by scriptural law, for he admitted a portion of the plaintiff's claim. If he already gave the 50, he is required to take only for his houses that he carried out the mission of the purchaser, requires the article. If the purchaser knew the article belonged to Reuben and the person telling it was only a broker, he must return the article to owner. He may, however, have a ban of ostracism issued against anyone who gives permission for an article to be sold 50. Those who agreed to the sale of 50 and then retracted after the sale was made. 7. The following was applied whenever a broker informed the purchaser that a specific article or piece of property belongs to a principal. Reuben, if after the purchaser requires the article, Reuben says, I don't want to sell it at this price. The purchaser must return the article. Reuben did not specify a price until the agent sell the article for this much. Whenever a broker loses an article or it is stolen or broken, he is liable to reimburse the owner for he is considered a paid watchman. 8. The following was applied when a person takes an article from the craftsman's workplace to send as presents to his future father-in-law's home and tell the craftsmen, if they accept them from me, I will pay you for them. If not, I will reimburse you slightly for the favor. If the presents were destroyed by forces beyond control while they are being delivered, the giver is liable to pay. If they were destroyed by forces beyond control while they were being returned, he is not liable to pay. If more stringent rules apply, if he took the articles with the intent of selling them to others, telling him if they will be able to be sold in such a place or until such and such a time, I will pay you such and such. If they will not be sold, I will return them to you. If they were destroyed by forces beyond his control, whether while they were being transported or while they were being returned, the person who took the article is liable to pay. Now, whenever an agent claims that losses beyond control occurred, causing him to lose this in this amount, he must take the oath required by agents to support his claim. Then he is released of responsibility. If the loss occurred in a place where it was likely that he will be able to find witnesses to corroborate his statements, or the matter is of public knowledge and witnesses could thus be found, he must bring witnesses to substantiate his claim. If he does not bring witnesses, his claim is not accepted and he is required to pay. An incident occurred concerning a person who holds his agent, bring 4 measures of wine for me with money of mine that is in your possession. The agent brought the wine for him, and it turned out to be vinegar. The agent says it's a large of a quantity of vinegar is bound to have been spoken about publicly. It is possible to substantiate the claim with witnesses. The agent must bring witnesses that the wine had not turned into vinegar at the time of the purchase, and thus free himself from responsibility. If he does not substantiate his claim, he must pay. Similar loss applied on all instances regarding entities where it is feasible to substantiate a claim. When a contract to claim concerns a hidden matter that is not easy to substantiate, the agent must take an oath concerning the similar loss applied in all claims to be issued by a partner and the like. Similar laws and similar apply with regard to a watchman. If it is likely the claim can be substantiated, the watchman must substantiate it, as will be explained. Hillchos Shluchim Eshuttin, Chapter 3:1. The following was applied when a person owns land and property that another person is using, or that he has movable property that he has given him as an entrusted object, and he seeks to appoint an agent to carry out legal procedures with that other person and expropriate that property or entrusted object from his possession, he must compose a deed granting a power of attorney. He must perform a kin certifying that he is granted power of attorney, telling him to take it to court, acquire it, and expropriate for yourself or the like. The principal is not to compose such a deed for the agent. He may not enter into litigation on behalf of the defendant, will argue or not the party with whom I have contention. Even if the principal does compose such a deed, the agent is no more than that, and any property that he acquires belongs to the principal, and any expense undertaken by the agent with regard to a dispute to which he was given power of attorney must be borne by the principal, for this is also written in the deed granting power of attorney. Any expenses that you undertake in this case, I undertake to pay. 2. If the principal transfers ownership to the person to whom he gave the power of attorney, granting him only a third or a fourth of the property his colleague is holding, the person granting the power of attorney, may enter into litigation concerning the entire holding, since he is entitled to enter into litigation concerning the portion that he owns, and he is justified to enter into litigation with him on that. He may enter into litigation concerning the entire amount. 3. When one group of brothers who have not divided the estate between themselves, one group of partners comes and lodges a claim on a portion of the property they assert to be their own. His claim involves the entire property. The defendant must respond to him, since this person owns a portion of the property in question. He does not need powers of attorney from the other partners. If the defendant prevails, another one of the partners cannot lodge a claim against the partners who engaged in litigation, telling him, if I had been there, I would have raised other arguments, caused the defendant to be held liable. So the person who engaged in litigation can tell him, why didn't you come and raise those arguments? For this reason, if the other partner was in another country, and the partner can seek out the defendant to enter into litigation against, telling him I do not agree with all the arguments the partner raised. Accordingly, the defendant can delay, telling the first partner either enter into litigation concerning only your share, or bring power of attorney to the other party, for I am holding the property belonging to both of you, and you both are involved parties in this case. Tomorrow your brother or your partner will come and also lodge a claim against me. 4. A husband needs power of attorney to lodge a claim concerning his wife's property. If, however, there is produce on the property, since he has the right to lodge a claim concerning his produce, for it belongs to him. He may also lodge a claim about the property itself, and does not need the power of attorney for it. If his wife did not own the property, he has no right to the produce. 5. Although a person has entrusted an object to a colleague or given him a loan with a movable property or money, and appointed an agent in the presence of witnesses to bring that object or loan back to him, the option belongs to the owner or the lender. If he desires to give it to the agent, he is no longer liable and is free of responsibility if it has not reached the principal before he gave it to his agent. If he does not decide to give it to the agent, he is not required to do so, for the agent is not the litigant. This applies unless the agent brings power of attorney for the owner of the trusted object. Every person who comes to demand payment from a colleague using power of attorney is described by the verse in Ezekiel, he did what is not good among his people. 6. When a person lodges a court claim against a colleague for either movable property or money he entrusted to him, and the defendant has already denied it, the plaintiff cannot write a bill giving another person power of attorney to collect this property or money from that person. The rationale is that he appears to be making a false statement, for he says, I'm granting you power of attorney to take everything that I own that so-and-so has, and so-and-so has already denied possessing anything belonging to the principal. Similarly, if the person is required to take an oath in response to a colleague's claim, that colleague cannot grant another person power of attorney to have the oath administered. The rationale is that he is not transferring the prospective agent an object of substance, and a person cannot transfer a power of attorney on a claim that involves merely words, for words cannot be transferred unless they are associated with a financial claim. 7. When a person has entrusted property to a colleague and desires to grant an agent power of attorney can bring it to Kinning Khalifa. It's not effective for money cannot be acquired through Kinning Khalifa. What should he do? You should give the agent a portion of land of any size and transfer the money to him by virtue of his acquisition of the land with the intent that he expropriated with this power of attorney. The agent may then go and enter into litigation and expropriate the money. If the person lent money to another person, he cannot compose a transferring power of attorney concerning it. This applies even if the loan is recorded in legal document. The rationale is that the loan was given with the intent that the borrower would spend the money. Thus, the money given by the lender no longer exists, and the person cannot transfer ownership of an entity that does not exist. The only way a person can transfer ownership of a debt is through a maimer shlushtum, which is a dictate whose rationale cannot be explained as mentioned above, or through transferring the debt by writing a deed, transferring the ownership of the promissory note and giving it to the recipient. Therefore, in this way, when transfers the lien that the note conveys. This is my understanding of the law from the Gemara. The Gaonim have, however, ordained that one may also grant power of attorney with regard to a loan, so that no one should take money belonging to a colleague and go to a distant country. They also ordained that if a person was granted power of attorney to collect money belonging to a colleague that was held by another person in order to demand payment of a loan from him, and the person transferring debt did not own land, he could transfer to him 4 cubits of his heritage in Eretz Yisrael, and then transfer the money to him by virtue of his acquisition to the land. Such statements appear to me to be extremely flimsy and existential, for who is to say that this person has a portion of Eretz Yisrael, and even if he is fit to receive a portion of the land that is presently not in his possession. The Gaonim who ordained this ruling did not say to let the law pierce the mountain. Instead, they explained that the ruling was issued only to intimidate the defendant, so he desires to enter into litigation and pay the money when presented with his power of attorney. He is no longer under obligation. Why is he no longer under obligation? For a person who brings this substantial power of attorney is no worse than an agent appointed in the presence of witnesses. If, however, the defendant does not desire to enter into litigation with a person granted the power of attorney, he is not compelled to give him the money or take an oath until the principal comes himself. Similarly, the Gaonim ruled that if a person granted a colleague a loan, whether it is supported by a promissory note or by a kin of witnesses, even though the person denied his obligation in a court, a deed granting power of attorney can be composed because the defendant is denying a claim involving a lien on property. If, however, the loan is supported by a verbal commitment, the loan is denied. And it is denied. The Gaonim did not ordain that a deed granting power of attorney be composed concerning it. 8. When a person granted power of attorney granted power of attorney to one individual and then desired to nullify his agency and grant power of attorney to someone else, he may nullify his first appointment. The person granted power of attorney, however, may not grant power of attorney to another person, for the principal might not agree, saying, I do not want my property entrusted to another individual. Therefore, If the agent had stipulated to be given the right to power of attorney to someone else and have that person grant power of attorney to another, the agent may write a deed grant the power of attorney to a second individual, and the second individual may do so for a third. Everything follows the stipulation. Now, when the person who was granted power of attorney waives the payment owed by the defendant, sells him the article he was sent to collect, waives his obligation to take an oath or negotiates a compromise with him, his actions are of no substance. The principal told the agent, I sent you to improve my position, not to impair it. Therefore, if the agent had the principal stipulate the agency is effective whether he improves his position or impairs it, his actions are binding even if he waives the payment of the entire obligation. 10. When Reuven is granted power of attorney and files a claim against Shimon, Shimon cannot turn him away, saying, maybe the principal sent you, appoint another person, and nullify your agency. If Reuven will tell, give me the article that was entrusted, and I will leave the deed recording my power of attorney with you. If the principal does, in fact, grant another person power of attorney, he has comes of law. Shimon is not liable for he gave the object person with power of attorney. 11. The following was applied when Reuven comes with power of attorney from Shimon and demands payment from Levi. Levi tells him nothing like that ever happened, but if Shimon wants, he may take an oath and collect the article. He claims to expropriate the money from Levi, and we claims we expose the money from Levi and have it kept in the court until Shimon comes, takes the oath, and collects the article. Similarly, with regard to any other claim that Levi makes that is dependent on Shimon, Reuven should enter into litigation concerning the matter. Regarding the matter, the property should be placed in court until Shimon comes in his questions. Reuven may have a ban of ostracism issued against anyone who issues a false claim to withhold payment and delay it. If Levi is required to take an oath, he may not delay and say, I will not take an oath until I have a ban of ostracism issued to the person of Shimon against anyone who issues a false claim against me. For the issuance of this ban of ostracism is merely a minor ordinance that later get ordinance the litigants will be forthright in their claims, and we do not delay having the defendant take an oath because it is minor ordinance. Hillchos Shluchim ושתפין chapter 4:1. When a partner desires to establish a partnership, how does each one acquire the assets invested by his colleague so that they are established? They are considered partners. If they desire to establish a partnership with money, each should bring his money and place it in a common pouch. Then each of them lifts up the pouch. If however they compose a legal document detailing the partnership and have witnesses testify they built from the kin Khalif, and they just bring 100 zuz for the partnership. The agreement is not binding, and the partnership has not yet been established. Money is not acquired through Khalif, and therefore, if they establish a partnership with regard to other movable property, when they enter into the kingdom, one should bring his barrel of wine, the other his jug of honey, they will become partners. Partnership established in this matter. Similarly, if they mix their products together or hired property in partnership, one left the jug and the other the barrel with which they desire to act as partners, the partnership is established. General principles: all means of acquisition the purchaser employs to acquire property can be used by partners to acquire the assets that are contributed to the partnership. 2. When craftsmen join together in a professional partnership, even though they perform a kidney with each other, they're not considered partners. It wasn't part of 2 tailors or 2 weavers stipulate between themselves. Whatever either of them earns will be divided between them equally. They are not considered partners. For a person cannot transfer ownership to a colleague of an article that does not yet exist. If, however, they purchase the cloth for the garments with their common funds, sew them and sell them, or purchase the woof and warp with their common funds, weave the garments and sell them, and a partnership has been established through the use of money, they are partners for whatever they earn as payment for their work, and their commercial activities divided equally. 3. When 3 partners enter into a partnership, one investing 100 zuz, second 200 zuz, and a third 300 zuz, and they all do business with the money. Whether they profit or lose, the profit or loss is divided among them according to their number, not according to the size of their investments. Even if they purchase a bull for slaughter, in which instead of slaughter, each one of them would take a portion of its flesh according to the size of his investment. If they sell the bull while it's alive, profit for or loss, proper loss divided equally among the partners. When does the apply? When they bought and sold with the money of the partnership. However, the money still exists within the treasury of the partnership and was not spent, but its value rose or dropped because of currency and fluctuations, depending on the ruling authority or the local populace. Property, the loss is divided according to the amount of money invested. When does the apply? When a party entered a partnership without making a specific agreement. If, however, they were stipulated the person who invested 100 zuz received 3/4 of the profit, and the person who invested 200 1/4. If they lose the person who would be given 3/4. If they lose, the person who would be given 3/4 of the profit would not suffer more than 1/4 of the loss, and the one who would gain 1/4 of the profit would suffer 3/4 of the loss. The money divided according to the stipulation. For every stipulation made with regard to financial matters is binding. 4. When partners make a stipulation and they contribute to the partnership for a specific duration of time, each of them can prevent this colleague from dissolving the partnership. Neither one can withdraw until the set time arrives, or the money in the partnership is exhausted. Neither can take his portion of the principal or of the profit until the end of that time. If they establish a partnership without making a stipulation, without establishing a set time, they may dissolve the partnership whenever any of them desires. This one should take his portion of the merchandise from the partnership, and this one should take his portion. If the merchandise is of the type that cannot be divided, or if making the division would cause loss, the article should be sold and the money should be divided. If there was a time when the merchandise of the partnership would ordinarily be sold, each partner can prevent his colleague from dissolving the partnership until the merchandise will be sold at the known time for such merchandise to be sold. Neither can take its portion of the principal or of the profit until the time of the division, unless the stipulation is made between them. If the partnership was owed debt by others, one partner cannot tell the other, let us not dissolve the partnership until we collect all the debt that is owed to us. Instead, the assets of the partnership is divided when the debts are repaid. Each one should receive his portion. The following was applied when the contract of the partnership was debt to another person. If they are not responsible for each other, they should divide the assets of the partnership, and when the time for the debt comes, each one should pay his portion of the debt. If they're responsible for each other, each one can prevent the other from dissolving the partnership until the time of the promissory note comes due and the debt is repaid. Why is each one given this right? Because one colleague can tell tell the other, saying that each of us can be required to pay the entire promised note. Let us continue to do business with the money until the date of payment comes. If his colleague tells him, let us divide the assets, you can receive all the money for the promised note, do business by yourself, and pay the note when it comes due. The other colleagues may still impede, saying, maybe I will lose, for two people make greater profit than one. 5. When a person gives a colleague money to go to a different country or buy merchandise, buy produce to sell as merchandise, or buy and sell merchandise while sitting in the store, the person who took the money may not retract and return the money to his partner until he goes to the place where the stipulation was made and returns, buys the produce and sells it, or sits in the store. The rationale is that this is considered as if he fixed the time to sell the merchandise.